Welcome to In the Name of the Law with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinus from Sinus Dramus Law Firm, Kent Wood of Wood & Associates, PLLC, along with Mary Chartier and Takura Nyemphakusa from Chartier Nyemphakusa, PLC. Now let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law. Today's episode, we're going to meet a police officer who was injured while on the job in an auto accident, the leaked opinion that could overturn Roe v. Wade, and obtaining a guardianship in a family law case. Stay tuned.
In the Name of Family Law.
I'm here with Kent Wood today, who is the owner and lead attorney at Wood & Associates in Lansing, Michigan. And today, Kent and I are going to talk about guardianship. So, welcome, Kent.
Thank you. Good morning.
And tell us a little bit about what does it mean to have a guardianship?
Well, a guardianship, and particularly what we do, it's usually guardianships of minors, because we do a lot of family law. Guardianship of minor meaning is you have the authority to make all of the major legal decisions for a child. Getting into school, medical care, dental care, setting appointments, all those things.
So what happens when a child or children are left at your house by the parent and maybe the parent is out of the picture?
Oh, no, we get this call often. If a child's left with you and left in your care for an extended period of time and you have no authority, there's different ways you can grant authority, but if you have no authority to make decisions, then you can seek a full guardianship as telling the court that this child's left with you and we don't know where the parent is or they're not helping us take care of this child and we need the authority to act. And if that's the case, barring some other things, the court will generally enter that kind of guardianship in place. There are other ways to get a guardianship established. If both parents have passed away, that may be grounds for it. If, say, the parents were never married and one of them passes away and the other parent doesn't have legal custody, that would be grounds to seek a guardianship as well. So if you're the grandparent and your son or daughter passed away.
So you started by talking about guardianships where the parent kind of has disappeared, but I believe there's another kind of guardianship where the parent is agreeing to allow their child to stay with like a family member, for example.
Well, right. So a child could be with you for an extended period of time, but the parent could grant you authority, right? You only need a guardianship if you don't have the authority to make decisions. So one aspect to do that is you come in, we'll help clients put up what's a power of attorney, or sometimes called a temporary guardianship, where it lasts for up to 6 months and the parent can sign it granting somebody the authority to make the medical, dental, school decisions for the child for a 6-month period.
And so if you have this piece of paper called a power of attorney, like the family member, the aunt or grandparent could go to school and register them with that?
Yes.
I mean, the schools will accept it, the doctors will accept it?
Absolutely. We have not had an issue with that being a problem. The only issue we have is now the caregiver, who's now taking care of the child for an extended period of time, potentially years, having issues with the parent who wants to come and they're afraid that the parent's going to take the child away. And then that's going to destroy what the child knows, the community involvement, the relationship with the child. So some of those parents, or caregivers, will want to seek a full guardianship. And there's different ways you can do that. You can do it with consent. The parent could consent, and it creates what's called a limited guardianship, where the parent can still have parenting time, but the caregiver remains the primary caregiver. And that's a good kind of transitionary period if they're going to go back to living with the other parent. Because usually the issue is just how the impact is going to have on the child. The hard part, it also helps, the caregiver to, protect the child from just being taken at that point. If the parent's life falls apart again, the guardianship will be in place and it'll be easier to turn it into a full guardianship at a later time.
So I've heard about limited guardianships that allow the parent to have parenting time. I've also heard that if they don't follow the plan for the limited guardianship, that eventually the relative or caretaker could seek to terminate their parental rights. So what other types of requirements are put on parents who enter into a limited guardianship?
Well, other types of requirements, they usually have to pay child support if they're working. If they've had issues with gambling or alcohol or substances, they usually have to go through some kind of testing and treatment and counseling and all that. And if they've had issues actually being a parent, sometimes parenting classes are a thing they're imposed. They're all reasonable things just to get the parent ready to be a parent again.
Right.
And that's all the caregiver usually wants, is to make sure the child's going to be safe after having the child in his or her care for such a long time.
And the limited guardianship is something that has to be approved by a court. Is that correct?
Yes, the limited guardianship and a full guardianship both have to be approved by the court.
But a power of attorney is outside of the courtroom?
Yeah, power of attorney is outside of the court.
So you mentioned this term a couple of times, that the child has been left for a quote-unquote extended period of time. What does that mean? Is it a month? Is it 6 months? How much time has to go by?
Well, it really kind of depends on what's set up for the child. If the child's already enrolled in school, we don't, or if the child needs medical care and you don't have medical treatment, or hey, every year insurance, each health insurance will have to be renewed, whether that's Medicaid or some other plan. If they're not have the authority to do that, the child will lose insurance. So when they're losing something they need for their care is usually what triggers it. So the extent of time matters only with 6, 7 months. But if there's all these things that are happening that are needed now, and the child's only been with you for a few weeks, that would be sufficient time as well.
And do you does the caretaker have to know how long the parent plans to be gone at that point? If it's just, let's just say 3 weeks have gone by only, do they have to be able to explain to a court, like, I don't know how long this person's going to be gone because they're...
Right, they're basically going to testify and state that, hey, I've tried contacting this person, they've not gotten back to me, I need to take care of this child, they need this care, I can't do anything without their permission, and I can't contact them, and here's the ways that I've tried. Obviously, the court's going to be more concerned if it's a shorter period of time. They're going to be kind of take it as what it is if it can prove it's 6 months of time.
So one thing you just mentioned was insurance and making sure that the child was on health insurance. Which of the guardianships will allow the caretaker to put that child on their own insurance?
The full guardianship will allow that, as long as there's a limited guardianship and the parents are working or able to provide it or get it in some way.
It has to be a court order.
Right.
Guardianship, not the power of attorney.
No, the power of attorney will not allow that.
Okay.
It'd have to be a court-ordered one.
So one of the things we talked about with the limited guardianship is that it's a really huge benefit to the parent because it guarantees that they're going to have a schedule to have parenting time, right?
Oh, yes, definitely.
But the downside for the parent is that if they completely are AWOL and don't show up for parenting time, don't continue to establish a relationship with their children, that the caretaker could then seek to terminate parental rights. So can we talk about a little bit about the requirements that the parents need to be aware of before they put their children in guardianship care?
Right. So the longer a child's in guardianship care and the longer you're not engaged with your child in some way, then there's a chance that the guardian could move for termination of your rights and potentially adoption of your child. But that termination would have to be based on some of your actions, whether you've done something that was harmful to a child, whether yours or another, but more likely is you've had little to no contact with your child for about 2 years or more.
2 or more years,
yeah.
Right?
That's kind of the benchmark there. And then also not supporting your child in that same period of time. And those are both important. That's why I tell a guardian, okay, if they're not seeing the child but sending support, that's going to cause a problem for trying to terminate parental rights. Right. But the guardianship does require the parent to take court action to change the guardianship. So there won't be any change without the court knowing or having some oversight of that process.
Well, this brings up 2 questions then. 1, how hard is it for a caretaker to obtain the guardianship? And 2, how hard is it for a parent to seek modification? Maybe not get rid of it, but just to modify it.
Well, if you meet the requirements and there's a need for the child and you don't have the authority to act, it's pretty easy to get the guardianship. In terms of terminating it, it just depends on how long the guardianship's been in place and what the change that they're asking the child to go through at the time of terminating. If you're saying, I'm coming to get the child and I'm moving across the country and we might never see you guys again, that's going to be slowed down. And
a judge might be a little bit worried about that. Okay.
So it really just depends on the circumstances when they're trying to terminate a guardianship.
And I'm guessing that a judge would want to make sure that the parent is done all the things to be able to support and take care of their child.
Absolutely.
Right. Well, great. This was very helpful, Kent. Thank you.
Well, thank you.
In the Name of Family Law is brought to you by Wood & Associates, PLLC. In the Name of Personal Injury Law.
Today we're going to talk about the realities police officers face with respect to their rights when they're injured on the job and in their patrol car. I have with me Steve Sinus, a partner at the Sinus Dramus Law Firm, and he brought with him a very special guest.
Well, thank you for having me, and I'm honored to have Bob Stump with me. Bob's a client of mine. He's here to tell his story about his severe injuries that he sustained in a motor vehicle crash in January of 2020 when he was working for the DeWitt Township Police Department. Bob, thanks for being here.
Thanks for having me.
Bob, can you tell us what happened the day of the crash?
Sure. On January 15th, I was working patrol when a neighboring agency requested for assistance for a flee and elude vehicle that they were chasing that wouldn't stop for them. After getting to the location that I picked out to assist with stop sticks to flatten the tire of the fleeing vehicle, she came over the hill on her side of the road, and just within seconds, she was on my side and hit me head on intentionally.
That's horrifying. Can you tell us a little bit about the injuries and the medical treatment you went through?
Yeah, so I don't remember a whole lot that after the accident, right after the accident, but I did unbuckle right before she hit me to get out of my car, and my knee hit the dash on impact and shoved my hip or hip socket, broke out on the backside. It's called your acetabulum, I believe. And so that was my major injury. I have back pain, and then I received a severe concussion, which still deal with a little bit of that today, but mainly my hip and my back issues.
You need to have surgery, don't you?
Yeah, in about a month I get a total hip replace.
So, Steve, can you tell us about the unique legal issues that someone like Bob faces when he's injured in a patrol vehicle as a police officer?
Yeah, so we may not think of police officers as having a unique set of rights if they're injured in a car crash, but in many ways they do. First of all, they're in the course of their employment, so they're entitled to workers' comp. They also have rights under the Michigan no-fault law, so they have to pursue their rights under both systems to pursue coverage for their medical expenses, lost wages. Bob's had to do that. Sometimes the two systems are kind of complicated to deal with, and some issues have arose here and there that we've worked out for Bob on those fronts. And then with regard to his rights against the at-fault driver, it is true that a police officer can bring a civil claim against the at-fault driver, but like all of us, when a police officer pursues that claim, the reality of what they can recover is usually limited by the insurance coverage that's available on that driver's policy. And in Bob's situation, unfortunately, this driver who was driving with such reckless abandon also didn't have too much insurance. And Bob's injuries are the type of injury that when you look at the past, present, and future damages he's going to sustain, and in my line of work, it's the type of injury that is worth several hundreds of thousands of dollars, if not, more than that. Unfortunately, she only had about a $50,000 policy. And so the next question for anybody in that situation is, do you have underinsured motorist coverage available? And with the police department, they do have that, or did have that for Bob, but it was only an additional $50. So I then had to tell Bob the bad news that in theory he has a right, and if you compare it to other cases in this field, his case is worth so much more than we can recover for him. And so it was limited to the 100 of coverage. And what it really brought to light for me is that we have people out there working in our police departments risking their lives in their patrol vehicles, and their underinsured motorist coverage could be increased pretty easily, or it's not that, it's not
the coverage held by the police department.
Right. And underinsured coverage can be increased without too much of an increase in the premium. And if they did that for police officers and increased their coverage, they would be further protecting them. And unfortunately, Bob didn't get that kind of protection. He's got a very limited amount of money that can be pursued when this person has permanently damaged his life.
So, Bob, what are your thoughts about the limited coverage that you've experienced, and can you tell us what other police officers should be aware of? What would you want them to know?
Sure. I was shocked when I found out how little coverage my department had, thinking if I am even to return to work, that's my concern for my family and providing for them. So after talking to other officers, they were shocked when they found out how little coverage that we had as well.
What should police officers in Michigan, Steve, understand if they are injured in their patrol vehicles?
If that happens, they need to understand their rights at the outset. They gotta understand what they have to do with workers' comp. They have to understand what they have to do with Michigan no-fault insurance. They then have to look at their rights against at-fault parties that somehow contributed to the crash. Perhaps sometimes in police situations you have multiple vehicles that could be to blame. So just like any situation, a very extensive investigation may be warranted. And then you got to investigate the insurance coverages that are there for any type of liability claim. So when a police officer is injured, they are going to look at the liability insurance policies of the defendants. And then they perhaps could access their own policy, and they're underinsured coverage to their own policy if that kind of coverage is available under their policy. It can be the case that because they're operating another vehicle that's not insured under their personal policy, there's not going to be underinsured coverage under their personal policy, which then leaves them with their coverage under the policy that their department bought. And so I would advise police officers to ask their departments to explain to them how much underinsured coverage do they have. And I think that unfortunately across the state of Michigan, there's probably not too much coverage that police departments are buying for their patrol vehicles.
And I'm guessing it's just because people haven't asked the questions and they haven't really thought it through and haven't really consulted with an attorney like yourself to understand what they should be doing to protect their officers.
Right, and that's why we brought Bob on here today. I mean, it's not to blame anybody in particular. It's to bring awareness to the fact that we have people risking their lives in patrol vehicles, and their insurance coverage could be increased to give them much better protection, and it's just not happening. And Bob has now had to live through that reality, unfortunately.
And what about the fact that the accident, has made it difficult for Bob to work? He was off work for a good period of time. Is that covered under the stations or the townships policy?
He has coverage for his lost wages through workers' comp, but there are some complicated aspects to that at times. And so thankfully he does have that coverage. But what we're talking about is a right that is for compensation for the loss of quality of life for the rest of his life.
Right.
And it's the type of claim that juries, when they hear, realize how valuable those claims are. Mm-hmm. And so Bob could go before a jury and get a big award. But the problem is that the coverage isn't just going to be there. There's nothing there to recover. And that's what
really
we're trying to bring awareness about. And these insurance buying decisions police departments have, they can do it differently, and they can increase the coverage. So hopefully they do.
So if you're a police officer in the state of Michigan, you should be asking your department what the coverage is, so you know that you and your family are protected, right?
Yeah, exactly. Bob, thanks a lot for being here.
Yeah,
Thanks for
thank you,
having
Bob.
me. Appreciate it.
Really appreciate it.
In the Name of Personal Injury Law is brought to you by the Sinus Dramus Law Firm. In the Name of Criminal Defense.
We are here today at In the Name of the Law with criminal defense attorneys Takura Nyamfukusta and Mary Chartier. Welcome back.
Thank you, Lisa.
Thank you, Lisa.
Now, in May, news outlets published what appears to be a draft opinion of what would overturn Roe versus Wade. Now, as of today's recording, that United States Supreme Court has not issued the decision in the case called Dobbs versus Jackson Women's Health Organization. But what do you, with this leaked opinion from conservative justices of the United States Supreme Court, mean for Michigan residents if it is published as it's written today?
For Michigan women, what this would mean is that if Roe versus Wade is overturned by Dobbs, and it looks like it will be, and that opinion should come out by the end of June from the United States Supreme Court, the law from 1931 would come back into effect. And that would mean that all abortions in the state of Michigan are illegal unless the mother's health is at risk.
Okay, so do we know who leaked the opinion and why? And also, what would happen to the person who leaked the opinion?
In short, we do not know who leaked it or why. However, what's clear is that this rarely happens from the secretive court rather. And Chief Justice John Roberts has actually ordered the marshal of the court to open an investigation into the source of the leak. it could be a career-ending decision for that individual, whoever it was. One theory is that the most concrete impact of the leak is to lock in the opinion essentially as is. And of course, another theory is that by revealing the severe nature of the opinion as it stood in February, a particular justice or clerk could be attempting to pressure the Chief Justice into pushing more forcefully for a decision that does not set up states to establish abortion bans.
Now, I wanted to say, when Kerr mentioned law clerks, that's been the real focus. The focus has been on the law clerks and assuming that one of them leaked the opinion. But I've been a law clerk at the Michigan Supreme Court, and there are lots of people who have access to those draft opinions. It's not just law clerks. So I feel like in defense of law clerks, although it was a very long time ago for me, there's no indication that it is from a law clerk. And a law clerk is a lawyer. It is usually at the US Supreme Court, someone who recently graduated from law school, but it still is a lawyer. And there are ethical rules that those folks need to follow. And there's no indication, again, that this came from a law clerk.
Now, do we think that the leak will impact the ultimate decision of the court?
Well, all justices are nominated by the president, confirmed by the Senate, and hold their offices under life tenure. Since justices don't have to run or campaign for re-election, they are thought to be insulated from political pressure when deciding cases, even big ones like this. Generally, the public is not aware of the court's internal activities, but cases like this one make the court's influence readily apparent in our day-to-day lives. Ultimately, the answer to whether the United States Supreme Court responds directly to public opinion depends on who you ask. The Constitution was written in a manner, though, that was intended to make the judiciary independent of the legislative and executive branches.
One thing that this does is, it has cast a tremendous spotlight on the justices, but it does make any sort of internal negotiating more challenging. And that's why it seems like it would be unlikely to be a law clerk, because law clerks would know how this works. Draft opinions go back and forth numerous times. A justice will, usually after oral argument, there will be a straw vote from the justices as to where they stand at that moment, and someone will be assigned to write the opinion. But that frequently changes. When a draft comes out, they may pick up a vote, they may lose a vote. Sometimes to get a majority vote, there needs to be a lot of changes in an opinion. That's why when you see a Supreme Court opinion, whether it's from a state or the United States Supreme Court, there frequently are concurrences and dissents, people not signing on to portions. What this really does, though, I think, is it makes the negotiation portion a lot harder. And for justices in general, they pay very little attention to what the public feels or thinks about an issue. They try and go strictly off the law, even on something as important as this.
So with what we know so far about the opinion, would it ban abortions?
No, it would simply leave it up to each state to decide what will happen within its boundaries or borders.
But we do know that a lot of states have a ban on abortions already. So with Roe being reversed, just like in Michigan, unless steps are taken, abortion would be illegal. And we know there are a very high number of states where abortions would be banned outright, or there might be those very limited exceptions for rape, incest, or the health of the mother.
So I've heard there's been a lot going on in the Michigan courts since the leaked opinion came out. Can you tell us what's happening?
So, Lisa, the Michigan Supreme Court asked Governor Whitmer to answer whether it should wait for the United States Supreme Court to decide the fate of Roe versus Wade before weighing in on the state's abortion ban law. And the court gave the governor 14 days to address the opinion, whether the recent Court of Claims preliminary injunction in Planned Parenthood suit against the Attorney General resolves the need for immediate consideration.
So to help out our viewers, can you explain just really briefly, what is the Court of Claims and a preliminary injunction?
Right, so that's when somebody says or sues the state and says the state should not do whatever it is that brings the person before the court. So it's a request to stop something dead in its tracks.
And so tell us what the lawsuit is about.
So it would stop the 1931 law that is on Michigan's books from going into effect. And that's the one that Mary mentioned earlier, where essentially in Michigan, unless the mother's life is in danger, any abortion would be a felony.
Okay, so is the Supreme Court opinion, at least what we know from the draft, limited to abortions only?
Well, that long opinion, it's almost 100 pages, that was authored by Justice Alito, conceivably extends, pardon me, to any decision made in private. That encompasses interracial marriage, same-sex marriage, and a host of other decisions that people frankly take for granted today.
Use of contraceptions?
Yeah, like contraception, right? Like contraception. So essentially, and it's a really fascinating opinion when you look at how many areas of our life the United States Supreme Court is saying that states can regulate. And what's really interesting is this is coming from a conservative majority. And historically, conservatives have said, government, stay out of our lives. Well, this opinion invites them not just into our bedrooms, it invites them into our doctor's offices, into our living rooms, and our kitchens. So, for example, if Michigan decided that they wanted to enact a law that said, because there can be no unplanned pregnancy without sex and without sperm from a man. So, or I mean, I guess you could have in vitro fertilization, but then that would be planned. So essentially, Michigan could enact a law saying every male, when they reach puberty, will have a vasectomy. And then only if a woman says, yes, I want to have this person's child, signs off on an affidavit, will that vasectomy be reversed? And if that sounds ridiculous to people, it's because you recognize that people have bodily autonomy. And we say, well, that's outrageous. No more outrageous than saying women can't choose what they want to do with their bodies. And beyond the issue of abortion, this really allows states to regulate our lives, our health, what we do in the privacy of our homes, what we do in the privacy of our bedrooms. I mean, it's very interesting that Justice Thomas's interracial marriage may now be something that a state can ban. And he's one of the lead proponents of this, overturning Roe. And, what also is really important here is I know so many people who say, I'm not interested in politics. I don't care about politics. Politics is what leads a president to be able to appoint justices who don't believe that there is a right to privacy in the Constitution. So property rights people have, but they don't have rights as to what they can or cannot do with their own body. And I think that this case and this opinion hits home that people need to vote. Whatever side of the issue they are on, people absolutely need to vote. And as you know, Lisa, we explore all these issues and more on our podcast called Constitutional Defenders. It's on every platform that podcasts are hosted on. And we will be discussing all of these issues and more.
Thank you.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukusa PLC.
Thank you for joining us today with In the Name of the Law. We look forward to seeing you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.